Good morning, everyone. Thank you for hopping on today's webinar. My name is Thomas Purcell. I am the Director of Employee Benefits here at URL Insurance Group. Uh, I see some unfamiliar names on the call, so thank you for joining us. For those of you who are not familiar with URL, we're a FMO general agency based out of Harrisburg, Pennsylvania. We're an independent brokerage, and we help support clients and agent partners across the country. We partner with a lot of different carriers and third parties, like my friend Earl here today. And this is the sixth episode of our 2023 webinar series. So at URL, we do a lot of things other than just employee benefits. We have a life markets division, an annuity solutions division. We also have a Medicare offerings department for any Medicare eligible folks or agents selling Medicare, as well as our HPO, our health plan options department that specializes in the individual penny insurance and group employee benefits. So, yeah, this is our sixth episode today. I'm happy to be doing these again this year. A lot of great attendance, great questions, engagement on the last few webinars. So hopefully we'll get that here again today. I know it's not always the most interesting topic, but our presenter here today, Earl, he's a really cool guy. So not hard to listen to by any means. I'll do some quick house cleaning items. I did my introduction spiel there, and then I'll hand it over to Earl, and we'll get right into this and try and keep it under an hour and save room for any questions at the end. So obviously, middle of your screen is going to be the presentation that Earl is going to be going through today. On the right-hand side of your screen, you're going to have a chat feature, a question and answer feature, polls, handouts. You can click on any of those. We'll start with the chat or Q&A. Please, at any time, feel free to type in any questions, and we'll try and address those at the end. If we don't have any time, we will be more than happy to follow. I always follow up with anyone I don't get to address at the end during the Q&A time. Handouts, underneath the handouts tab, Earl was nice enough to share his presentation with us today. So if you want to keep the presentation on hand, scribble any notes on it, feel free to download that presentation. There's also a link to our URL website where you can check out all the different departments, services, offerings, the people here at URL. That's our website. You can check everything out at. There's also a link to our webinars tab where you can check not only future webinars that will be coming up that you can register for, but also webinars we've done in the past. So we record all our webinars here so that they're easily accessible for our clients and agents at any time. Quite frankly, I'll go back to our website and look at some recorded webinars from years past. So please consider that as a resource. Feel free to use it at any time. I believe those are the house cleaning items. So Earl King is joining us here today from Principal. I don't want to steal too much of his thunder. So Earl's been a partner for a few years and a great guy to work with. He really takes a collaborative approach. He's not, he looks at the group, he looks at the agent, he looks at the opportunity and finds ways to really provide the most value. And that really kind of coincides with what we try and do here at URL. So I really enjoy working with Earl. He's really knowledgeable, really good at what he does, but he's just a really good guy all around. So without further ado, I think that's it, Earl. I'm gonna hand it over to you, man, to take care of this presentation.
All right. Thank you. I appreciate that warm introduction. Some very nice things there. I appreciate that. So again, everyone, my name is Earl King. I am the sales rep that works with Principal Financial Group that works with URL. Today's session is going to be reviewing the Family Medical Leave Act, what it is, how it works. We'll take a quick look at kind of what it is, who's responsible, what employers' responsibilities are for providing FML to their employees, the employee eligibility. We'll look at how it intersects and overlaps with the Americans with Disabilities Act, as well as with short-term disability, statutory disability, and then workers' compensation. We'll look at some of the challenges that employers face in managing their FMLA or their leave programs, and then some strategies and tactics that you can employ to help provide them some direction and some guidance to make sure that they're compliant. And again, we'll leave some time at the end. There's a chat feature. I think Tom will be managing that as well. So if questions come out throughout the course of the presentation, don't hesitate to throw them in there as well. So again, taking a look at FMLA, what it is, FMLA entitles eligible employees of covered employers to take up to 12 weeks of unpaid job protected leave for specified family and medical conditions. So we'll take a look at kind of what some of those conditions are, how employers can manage those. Again, what employers are responsible providing that coverage as well. So the intent of FMLA is to provide employees with the ability to balance their work and family lives, ensure that they can take the leave needed to attend to whether it's an illness, family. We'll to look at some of the different conditions, paternity, maternity leave, those kind of things, and ensure that they have job protection as they do it, and that the policy is consistent across all employees so that the employer remains compliant and it minimizes discrimination so that they're not put in a position where they could face a lawsuit for treating one employee one way and another employee a different way for a very similar type of leave or the same type of leave, so that it minimizes their exposure in that regard. So reasons to take FMLA: the birth of a child, place of child for adoption or foster care, to care for a family member, a serious health condition, and there are certain types of military leave that also qualify. Employers can take up to 26 weeks of unpaid leave to care for a sick or injured relative in the military, or, oops, oh, there we go. Sorry, the screen was jumping around on me there. Excuse me. So a covered military member in the employee would be considered the employee's spouse, son, daughter, or parent who is on active duty or call to duty status. An employer may require certification to support the leave from a healthcare provider. They may also require a second or third medical opinion at the employer's expense and a periodic recertification of a serious health condition. So important to kind of recognize those factors and when employees can take leaves to take care of their immediate family members. So different types of leave. Continuous. So again, taking continuous time off of work is a little easier to manage, and it is described as 3 days or more, or intermittently, with a reduced number of days in a work week or a number of hours in a day. This can be a little more challenging, and it can be as small as 1 minute more than 3 days. So that will be considered intermittent. And again, unplanned intermittent leave is the issue that is consistently cited by employers as their biggest pain point. If an employee needs leave for a planned medical treatment, they must give their employer a reasonable effort to make scheduling so that it doesn't interrupt the employer operations. When there's an unplanned leave, it makes it a little bit more difficult, not only for the employee but for the employer to manage coverage for different schedules or workloads to make sure that employee's responsibilities and job functions are covered. So a little bit of a challenge there in managing intermittent leaves. Covered employers, or which employers are responsible to provide FMLA: private employers with 50 or more employees. So not all employers have to offer FMLA leave. Government agencies, there's no minimum number of employees required for government agencies, and the same with schools, no minimum number there in terms of public, private, elementary, secondary schools, regardless of the number of employees are required to provide FMLA. Eligible employees. So an eligible employee to take FMLA leave, employers must have worked at a covered employer's location for a minimum of 12 months with a minimum of 1,250 hours of service. The 12 months do not need to be consecutive. It includes all aggregated time employed over the last 7 years, the 1,250-hour requirement, even for exempt non-overtime employees whose actual time worked may not be worked. So, for example, if an employee is scheduled for 40 hours, has a big project that week, works 60 hours for FMLA eligibility, that would count as 61 hours or 60 hours if they go over that minimum or their required 40-hour regular schedule. The next condition employees must meet for FMLA is they must work at a location where the employer has at least 50 employees within 75 miles. So employees at locations with less than 50 employees must be located within 75 miles of another employer location that has more than 50 employees in order to be eligible. So again, a little tricky there. But as an example, looking at a company that has a total of 100 employees with 85 of those employees at the home office and then 15 employees that are kind of scattered across the country, different satellite offices that are, say, over 150 miles away. Using this example, the employees at the satellite office aren't eligible since they are fewer than 50 employees at their locations and they're further away than the 75 miles from their home office. Important to note that employers can choose to offer leave for those 15 employees that are scattered. That's up to them, but they're not required to do it. So there's some different rules there. Also, some different rules for airline employees. So again, you're looking at kind of a specialized industry that has some unique schedules, non-traditional work schedules. So airline flight attendants, flight crew members are subject to a special eligibility requirement for FMLA. They're eligible for FMLA if during the 12 months prior to their need for leave, they've worked or been paid for at least 60% of their monthly guarantee, and they've worked or been paid for at least 504 hours, not including personal commute time, vacation time, medical or sick leave. So, a little bit of a unique wrinkle in the FMLA legislation as it pertains to airline employees and their eligibility, just because of the unique nature of their schedules. Paid or unpaid. So FMLA is an unpaid leave, other than certain states, California, New Jersey. Some states are starting to implement. This presentation is actually a little bit out of date because it seems like states are adding it each year. So they're adding a paid family leave component. However, if an employee has sick, vacation, or personal time available to them, they may choose to use that time along with their FMLA so that they can continue to be paid if they're located in a state that does not have a paid family medical leave program. Employers can require employees to apply paid time off, such as PTO or vacation time, to some or all of their FMLA leave. So it's the employer's requirement to say, okay, look, you're going to have that FMLA period. We want you to start using your PTO through that period so that they're not taking kind of the 12-week FMLA leave and then on the back end that they can start to burn up, maybe their PTO or their sick bank and use time on the back end to continue that leave of absence period. So again, employer discretion whether or not they require the use of PTO or sick leave to coincide with their FMLA period. So looking at the employer's duties, all employers are required to post a notice about FMLA where employees can see it. A lot of times you'll see those notifications posted in a break room or a lunch room. In addition, they must provide general notices to each employee. For instance, in an employee handbook, you'll see it a lot of times posted on an intranet site, those types of things. Copies of those notices are also available through the U.S. Department of Labor's Wage and Hours Division. Employers must also continue any group health coverage for the employee. If the employee makes a contribution for the coverage, the employee must continue to make that contribution to that coverage. So it can be a little tricky managing that if someone's out on an unpaid leave. However, so if they're not getting paid, their contributions, which are usually pulled out of their paycheck, there's no paycheck coming. So it can make that situation a little trickier for employers to manage as well. Employers must also restore the employee to their original job or to an equivalent job for equivalent pay, benefits, and other terms and conditions of employment once the employee returns from their leave of absence. So important to um, for employers to recognize that an employee may take a leave. um, Job function, the world keeps turning, as they say. So it's important for the employer to make sure that those job functions are still covered while that employee's on leave. So they may put another person in that position, but when that person comes back from their leave, they need to be restored to that position or a similar position based on pay, benefits, etc. So the job protection component, what it does is basically resume that employee to their pre-leave or an equivalent position. When an employer returns to work from FMLA, their employer must give them either that same job that they had before they left or a position that is equivalent with benefits, pay, working conditions, and seniority. So important for those elements to be hit as well. There is no FMLA protection for layoffs or a reduction in workforce, nor its entitlement to accrue seniority while on leave. Key employees may not be guaranteed reinstatement to their positions offering FMLA leave. A key employee is defined as a salaried FMLA eligible employee who is among the highest paid 10% of all working employees. So again, different employee groups have different job protection status. Important to identify where they'll fall. But again, the kind of main component is to be able to restore that employee on leave back to their position or an equivalent position with all of those components, benefits, pay, working conditions, and seniority taken into consideration. Looking at some prohibited employer conduct, or what employers are uh, not allowed to do, I guess, is the simplest way to say it. According to the Department of Labor fact sheet, it is unlawful for an employer to interfere with, restrain, or deny the exercise of or the attempt to exercise any right provided by the FMLA. It is unlawful for an employer to discharge or discriminate against any individual for opposing any practice or because of involvement in any proceeding related to the FMLA. So, more specifically, the Department of Labor prohibits employers from refusing FMLA leave for an eligible employee, discouraging an employee from using their FMLA leave, manipulating an employee's work hours to avoid responsibilities under the FMLA. So, again, an employer that may have feel that an employee is going to be taking a leave or exercising their FMLA rights. So to kind of protect them or restrict them from doing it, they kind of proactively reduce their hours. So maybe that employee is no longer eligible, or they do some things to manipulate the employee's schedule or status within the company. So that they don't have access to that FMLA. Again, unlawful for the employee to engage in those practices. Using any employee's request for or the use of FMLA to negatively factor into employment actions such as hiring, promotions, or disciplinary actions, and then counting FMLA leave under no fault attendance policies. So again, the FMLA Act is designed to provide the employee with those protections, but also for the employer to remain consistent in exercising how they're treating these different types of leaves across their entire employee population. Looking at the employee's duties, again, these employees have there's responsibilities and requirements that fall on the employee. They must give 30 days advance notice of the need to take FMLA when it is foreseeable. So again, there's different types of leave. There may be the need to take or to exercise some FMLA for an employee that is unexpected, that they can't plan for. But in the event that they intend to take that leave, and it is foreseeable, they need to provide that 30-day advance notice to the employer so that they can kind of prepare, again, make sure those job responsibilities are covered while the employee's out. They must comply with usual and customary notice and procedural requirements for requesting leave, which may include providing written notice of the reason, anticipated departure, and the duration of the leave. They must explain reasons for leave to allow a determination of the leave qualification, specifically referencing the qualifying reason for the leave, and they must also provide a medical certification to substantiate a serious health condition within 15 days of that FMLA request. So again, there's responsibilities that fall on the employee to provide that information to the employer, so that the employer can then make that FMLA determination um, appropriately, and making sure that it is a qualifying event. Some of those things that we talked about earlier in the presentation. So looking at some of the FMLA challenges that employers are facing, um, employees are becoming more aware of the law. They're more aware that they have this. Certainly, paid family medical leave is becoming more and more of a topic. And as employees become aware, they're using their leave more frequently. So keeping up with and administering different employees' leaves of absence. It creates challenges, requires leave decisions that are fair, accurate, and compliant with the ever-changing federal and state specific laws that can be difficult to interpret. So again, you're looking at kind of the bubbles on the screen, increased usage. So there's more employees taking leave, more employers, or excuse me, more employee leaves that the employer needs to manage and remain consistent and compliant. So it's important to make sure that the FMLA is administered appropriately. And then again, the challenge in managing those leaves, making those different determinations and decisions when the information comes in, can create a number of challenges for HR departments as they try and remain compliant. So factors that increase the FMLA usage, employee dissatisfaction, loosely managed programs. So again, employee dissatisfaction, you're looking at disgruntled employees, they're not happy, the working conditions have changed. Certainly as we went through COVID and that period of time, there may have been people that were, in fear of losing their job, or so they would take some FMLA leave. There was obviously some abuse, but there was the need for these programs as well. So, in some cases, loosely managed plans, employers just sort of defaulted to, we'll just let everybody go because we don't want to say no, or we don't want to be outside of compliance. So the path of least resistance is just to approve these leaves. A large number of what's referred to as the sandwich generation of employees that must care for both parents and children. So as folks are aging and living longer, there's kind of that responsibility. I think I'm kind of in the sandwich generation myself right now. I've got teenage boys, I've got parents in their 70s, all are healthy, happy, and all of those things, which is great. So no need for FMLA for me. But again, you have folks that may have different types of responsibilities, whether it's caring for a parent and also caring for their own family, their children. So industry impacts can impact the usage as well. So for instance, blue collar workers production may leverage FMLA leave during disasters such as floods, tornadoes, hurricanes to kind of operate their own side businesses. That was a kind of an issue for some abuse, where you had some blue collar construction workers that just sort of use their FMLA leave to kind of go off on their own. They have a 12-week kind of protected job status, but they're kind of picking up work on their own on the side. So FMLA usage and misuse is often escalated at employers where attendance is critical. So important to understand, obviously different industries, different work schedules, those types of things. It's more prevalent that there is abuse when there is a specific attendance critical schedule in place. So mismanagement of FMLA can be costly. So mistakes can be costly, as shown on the slide here. It's best to make sure that the knowledge is there to help offset them. So for the first time in 2010, managers and supervisors were individually sued and held personally liable for damages. In this specific case, Noradetsky versus Cardone Industries. There's been a number of other cases that you'll see on the screen. And again, you're looking at 6, 7, 8-figure settlements because of mismanagement of these FMLA programs. So it's important for employers to recognize what the responsibilities are to remain consistent and compliant. So looking at how all the different types of leave or different types of time away from work programs kind of integrate together. So you'll see on the screen, you have your FMLA, which we just sort of reviewed. Then you have different state laws. So again, you have different state requirements. Those in the disability market understand that there's states that have statutory disability plans, such as New York, New Jersey, California. I think there's 7 or 8 total now that have mandatory statutory disability plans. Paid family medical leave. Connecticut rolled that out. There's a number of other states that are starting to roll out different leave programs. So it's important to understand, you know, you may be working with an employer that has employees in multiple states that have different requirements. The Americans with Disabilities Act, or the ADAAA as it's often referred to, we'll talk a little bit more specifically about that act, the Amendment Act, and how worksite accommodations come into play. Then there's obviously short-term disability insurance, and then workers' comp. So understanding the differences in all of those different programs, what's available to employees, and what would qualify, which types of leaves fall under those plans. So we'll take a quick look at a map, just to give you some of the idea of what different types of leaves are present there. So again, federal leaves, your FMLA, USERRA, ADAAA, which is basically leave as an accommodation. So we'll talk a little bit about how leave as an accommodation versus worksite modifications and those types of things, and how those different things play into the ADAAA law there. And there's different state leave plans. So you have those listed on the plan, or excuse me, on the screen there. And it just kind of gives you gives you an idea of different states and the number of different state leave plans. So you see the darker states here are the ones that have over 9 different types of state-specific leave plans. And again, California, New York, Washington, obviously the tops in those categories. So I talked about ADA. The Americans with Disability Act requires employers to provide a reasonable accommodation to disabled employees, which may also include a leave of absence. So a person is regarded as having a disability if they have a mental or physical impairment that substantially limits a major life activity, or if the person has a record of disability. So a reasonable accommodation is a change that can accommodate the employee with a disability without causing the employer undue hardship. So that undue hardship is kind of a key component there. I'll talk a little bit more about that as we move on. But again, this may include leave of absence as an accommodation. So important to understand that, a lot of times you'll think, okay, ADA, I need to make a reasonable accommodation for this for this employee. So you automatically think of different accommodations at the work site, maybe a sit stand workstation, or a headset or ergonomic keyboard, those types of things. But also coming into play is leave or adjustments in their schedule to make for those accommodations as well. So looking at what is ADA, we talked the ADA, Americans with Disabilities Act of 1990, the ADAAA, which I had referred to is the Amendment Act that was added in 2009. That made changes to the definition of the term disability, clarifying and broadening what that definition is. Therefore, the number of types of persons who are protected by the ADA and other federal disability non-discrimination laws, it was designed to strike a balance between the employer and the employee interests. So those provisions are enforced by the EEOC, or the Equal Employment Opportunities Commission, not the Department of Labor. So important to understand the differences there. And again, the ADAAA Act, or the Amendment Act, was really designed to give a little bit more clarity. There was some ambiguity in some of the terminology. Again, I mentioned undue hardship. How is that defined? What are the employers, what do they consider an undue hardship? So it's some of those terms, again, a little bit of ambiguity, and the ADAAA was designed to kind of tighten up some of that verbiage. Different examples of impairments or conditions. You'll see them on the screen. I'm not going to read through all of them there, but again, that was expanded through the ADAAA to list specific requirements or specific conditions that would um, fall under that protection. And then looking at major life activities. Again, you look at kind of the activities of daily living, if you will, eating, walking, taking care of oneself, as well as performing, manual tasks. And then obviously those you'll see on the screen are what are defined as the life activities that can be inhibited by a disability. And then again, the protections that are in place. So some of the questions to consider um, when evaluating an employee's request for an accommodation and questions when evaluating their disability. So, what limitations is the employee experiencing in terms of their abilities to perform their job functions? How do these limitations affect that employee and their job performance? So, again, from a performance perspective, there's a lot of different ways to look at that, whether it's attendance, production, productivity while they're working. So, those different things. And then what specific job tasks are problematic as a result of those limitations. So when evaluating that, it's important to take those things into consideration when considering what accommodation is available to either reduce or eliminate those problems. Are all those possible resources being used to determine what possible accommodations are available? Has the employee been consulted or regarding any possible accommodations? So again, important for the employer and employee to engage in conversations about what types of accommodations may be available. Again, maybe adjustments to the work schedule. It may be workplace modifications, those types of things. And then once the accommodations are in place, would it be useful to meet with that employee or evaluate the effectiveness of those accommodations to determine whether additional accommodations are needed? So again, it's an ongoing process. It's important for the employer to remain engaged with the employee so that they can learn about, okay, what do we need to do? What have we done? Was it effective? And just to continue to monitor and evaluate the effectiveness of those accommodations. So looking at FMLA and ADA together and how they kind of marry, when an employee reports their own serious health condition for FMLA, approval for FMLA doesn't automatically mean the health condition is treated the same as an ADA qualified disability. So according to the ADA, a disability is an impairment that substantially limits one or more major life activities. So when an employee qualifies for FMLA leave, employers should evaluate whether the employee may require a reasonable accommodation or an ADA accommodation. The employee is entitled to the benefits of whichever law provides the employee with the greatest protection, which is typically going to be FMLA. Employees taking FMLA leave who run out of leave time can make a claim for an extended leave as an ADA or reasonable accommodation. So important to understand how those two things can marry together there. But again, there's different requirements for these two laws. Sometimes they can intersect, other times they don't. And again, just because a leave qualifies under FMLA, it may not qualify under ADA. Another important thing to kind of point out is on the disability, on the carrier side, a lot of disability contracts will have a workplace modification benefit in it. So that if an employee is out on a long-term or short-term disability, the disability carrier may also be able to provide a benefit to the employer to make workplace modifications. So again, that's not going to help with the need for reduced work hours or an adjusted work schedule, but some of the other things, the other accommodations that I had talked about, whether it's handicap accessibility, different types of equipment that may make an accommodation that may help an employee with those disabilities. Those things can be available through the disability carrier. So important to engage with them to understand, what's available not only to the employee but also to the employer. So looking at short-term disability protects employees' most valuable asset, which is their ability to earn income if they're sick or hurt. So a lot of times, this is kind of where I spend a lot of my time on the disability side, short-term and long-term disability. So understanding what's available. A lot of times people just think short-term disability, that's kind of maternity coverage. If I, I want to make sure that I have that, if I plan to have children, it's very important. Younger females focus on short-term disability, but again, there's a number of different programs there that that can help employees that lose the ability to work perform. And again, I always tell people the difference between disability and some of the worksite products you may see, critical illness, accident, those types of things. Disability coverage is designed to protect your paycheck. So to keep that income coming in so that you can pay, mortgage, electric, utilities, all those types of things while you're disabled. So looking at how FMLA and STD both can run consecutively or concurrently. They can run together if the FMLA leave is for a serious health condition that could qualify for both. So again, understanding the nature of the disability, what would fall under which category, and that those periods can coincide. Disability protection will pay the employer for lost wages while they're out on FMLA, but again, FMLA, depending upon the state, is just really that job protection component versus the income protection component. So important to understand that the STD can provide that income protection. Looking at workers' comp, very similar to disability, but again, is state mandated insurance program designed to protect people who are injured on the job. In exchange for compensation, employees usually do not have the right to sue the employer for damages related to their injuries. So again, workers' comp was designed to protect employers against litigation, designed to protect employees if they were injured at the workplace. As somebody who's had a workers' comp claim years and years and years ago when I was in a blue collar job slinging beer in the summers and blew my back up, it covered, income, medical, all those different types of things. So important to understand how the difference between, again, workers' comp and short-term disability. So you're looking at kind of on the job versus off the job, and then how these marry together. Again, FMLA and workers' comp can also run together. Must be a qualifying serious illness or injury. So again, not every workers' comp claim may qualify for FMLA and vice versa. If approved for workers' comp, the employee is typically ineligible for short-term disability. So important to understand your short-term disability plan, again, on the job and off the job, and those differences there, and what employees may be eligible for. So the questions to kind of ask, is the injury work-related? You'll see that a lot of times. You'll get, I get a lot, from our medical carrier, where you'll get kind of a questionnaire if you went to the doctor or an ER or something, and they'll ask you those questions: is, was this work related? Was it related to an auto accident? So understanding those different questions. Does the employee have a serious health condition? And again, does it qualify for FMLA? And then does the employee have a disability that would qualify for STD and possibly an ADA accommodation? So important to kind of evaluate those different questions as well. So looking at an example, an employee that has diabetes. So diabetes can qualify an employee for an FMLA if the employee is under a doctor's care and the symptoms are incapacitating. So there's obviously many Americans have diabetes. There's some that it impacts them more significantly than others. Others can manage it through diet, exercise, medication, those types of things, where it's not hindering their job performance and is not creating the need for FMLA. So again, important to understand and engage with the employee's physician to find out what limitations are there. What about short-term disability? Does that same employee qualify for STD? So diabetes by itself is typically not a qualification for short-term disability unless that disease is uncontrollable and the employee can't perform their job functions. So again, looking at a short-term disability contract, you're going to need to have, depending on how the contract is structured, the loss of duties and or the loss of earnings. So it's important to understand how the contract is structured, whether it requires the loss of both duties and earnings, or if it requires just one or the other. which is how the principal contract is structured. We have an or definition in all of our short and long-term disability contracts, which allows employees to qualify with either the loss of earnings or the loss of duties. So important to understand that contractual language, and again, just a generalizing a condition may not, it may be a difficult question to answer. So I always tell people, if you think you have a claim, file a claim, let a claims analyst review it. That's the easiest way. It's very difficult to answer, hey, does diabetes qualify for short-term disability? The answer is maybe. It's very specific to the situation. So what about looking at same condition for ADA? So generally, employees who qualify for FMLA leave because of a disability qualify for a reasonable accommodation under the ADA. The employee may ask for extended time off of work. The employer may accommodate the employee by providing them with breaks to eat or drink, take their medication, test their blood sugar levels. So again, that's an example of kind of an adjustment to the schedule, or creating more accommodations, so longer breaks, more breaks, so that employees who may be suffering from diabetes can manage that condition while remaining at work. So it's an example of something that would fall under the ADA, but not necessarily FMLA or short-term disability. So looking at some strategies and tactics that employers might use to manage the FMLA leave process. So limiting the abuse of intermittent leaves. It's important to connect employees with the available resources to them, employee assistance programs, different types of things like that. Principal offers, again, many disability carriers offer an employee assistance program that's attached to their disability contract. I always like to focus on that because it's a feature that employees can use and not be disabled, right? So nobody really, I've been in group insurance for over 20 years doing life and disability, and without fail, nobody really wants to talk about being disabled or dying, or family members passing away. Those types of things aren't really hot topics. But if you can explain that, hey, you have a lot of resources through an employee assistance program, you have face-to-face consultations, they can help you with any type of issue, whether it's elder care issues, child care issues, divorce, financial issues, all those types of resources. Those things that are available to the employee can help prevent a situation or a condition from escalating. So it's important that employees or employers understand what's available to their employees, and that they promote those programs proactively to help them kind of explore what's available to them. Exploring work continuity options. So again, what's available to maintain that the employee can have a connection to the employer, can continue to work in some capacity. Maybe again, looking at a reduced schedule or an adjustment to the schedule. Important to stay in touch and communicate with the employee throughout their treatment, throughout their leave, to understand where they're at in the process, and try and get a feel for what can come down the pike. And then educate employees, make sure that they're knowledgeable about the laws, what's available to them. And then lastly, outsourcing, excuse me, still early, outsourcing services. So absence management programs, and it's become increasingly more popular. I would say, in my 20 plus years of doing this, there was a stretch there where outsourcing FMLA was the hottest topic going, and everybody was looking to do it. It's become kind of the standard for larger employers now, where they're looking to kind of have a carrier outsource their absence management programs. And really, the reason behind it is there's so much that changes, and it's so difficult for employers that typically have an HR department that's overwhelmed, understaffed, to try and stay on top of all these different federal requirements, state requirements, all these different programs that are available to employers and employees. It's much easier to outsource that to a carrier, let them integrate that with either their disability programs, manage all these different state leaves. Important to understand who that may be available to, what different carrier requirements. Usually there's a size requirement or total number eligible lives, where carriers want to get into that segment. And again, the integration and how those plans are structured, because carriers can also really kind of customize a la carte their absence management programs, so that they may just manage the FMLA, or they may incorporate ADA with it, or they may look at different state-specific leaves, different company-specific leaves, so they can customize those programs to make it a little simpler for the employer to manage. So looking at different management strategies, so use FMLA as an early warning system for short-term disability. So detect a potential kind of costly health issue. Employees are more likely to request a short-term disability. So looking at that and understanding, okay, this employee is requesting an FMLA. It looks like it's a condition that's going to kind of flow into a disability claim. So understanding that, and then having a single source from FMLA and STD administration. So if you're outsourcing that, the carrier is remaining consistent so that the employee is constantly educated into what their rights are, what's available to them, and they kind of have a single point of contact that manages both of those periods. And then again, using a knowledgeable FMLA resource that can stay on top of the constantly updated regulations. That's the most difficult part of the process, is the constant changes and the differences in different states and different state required leaves. So if you're using an outsourced provider, they should be able to help find and analyze any kind of perceived abuse and challenges to some of these leaves. So that's another advantage in terms of protecting the employer, staying consistent, and then again, having a knowledgeable kind of industry expert that can manage all of these different types of leaves in one place, and then provide that employee with a single point of contact for all these different types of leaves that have available to them. So looking at some tactics to consider, important to plan ahead. So start thinking about how to proceed about 3 weeks before the FMLA leave time expires. So you want to know what's, once that 12-week period ends, what's the next phase? Again, there could be a request for an extension of that leave as an accommodation. So there's things there to consider as well. Ask for updated medical information that supports the employee's need for an extended leave or other accommodations. So again, staying on top of the process. It's not really, okay, we approve them for leave. We'll see you in 12 weeks and you can come back to your job. It's an interactive process that you continue to go through. Talk about the need for any workplace accommodations with the employee, recognizing, again, leave itself may be considered an accommodation. So an extension of the leave, and or looking at work schedule adjustments, using that diabetes example, creating more breaks to allow the employee to test their blood sugar levels, to make adjustments, take their medication, those types of things. Important to document all actions, every interaction in a precise and thorough way. And again, if you're outsourcing that, there's usually kind of a centralized hub where all that communication is documented. It's important to make sure that every interaction is documented thoroughly. Assess attendance policies and what the level of decision maker is required to act on a violation. So again, determining that decision maker. Don't authorize managers to terminate employees for attendance issues without consulting higher level management, because again, doing so could open you up to lawsuits. So understanding your employer corporate structure to determine who is going to manage those leaves and that communication, who's authorized to make different decisions, whether it's terminating an employee, extending those leaves, those types of things. And then lastly, as we kind of wrap up here, just some key points to keep in mind. The 4 key points to kind of walk away from with the seminar. I think kind of the overall arching one, that employee leaves are just difficult to manage. There's a lot of moving pieces in terms of what different programs are available to them. Again, we looked at different conditions that, you may have 2 employees that have the same condition, but are very different. So again, using that diabetes example, somebody who's a little bit more debilitated by that condition versus somebody who's able to manage it, again, doesn't impact their job performance. So it can be difficult in that regard. It's important to have a basic understanding of the laws around absence management, but also understand that there's state-specific laws. There's a number of different components and moving pieces. So it's important to be strategic when dealing with an employee leave, engage with that employee, make sure that everything is documented. And then again, Larger employees for sure want to consider outsourcing to experts in the field who can help manage that process. Carriers that manage absence management programs have specialists that are focused in each of those states so that they're constantly updating those different changes to state regulations, uh, different states that are implementing, again, paid family medical leave laws, statutory disability programs, and making sure that all of that stuff is current. Because as things change, I'll just use New York and New Jersey as an example. As TDB and DBL, those statutory plans were often, it was like, okay, we know those two states have those plans, but they're constantly changing, and they're very, very different. New Jersey has a very rich benefits, 85%. I think the max is over $1,000 a week now, whereas New York, it's $170 a week benefit. So it's very different. You both have statutory disability, but the plan is very different. So understanding that that you may have employees in that state that also have their statutory disability, and they also have access to maybe an employer paid short-term disability plan or a voluntary short-term disability plan that can kind of coincide with that statutory plan, understanding how those things marry together. So that is all. Any questions, comments, anything at all? Tom, I don't know if you see anything in chat questions or anything.
Yeah, thank you, Earl. That was super informative. I can speak from personal experience. Sat through a lot of seminars, a lot of webinars, a lot of conversations on FMLA, and this was definitely one of the more straightforward and concise presentations. So I appreciate that. I love when there's real life examples included as well, and you did a great illustration on that diabetes example. Um, did see some. I think this was a private question maybe that came through, but maybe you can help answer it. Um, well, before I get into that, I think you brought up a good point. The hierarching theme here is it's very complicated, all the inner workings and layers to these FMLA and ADA and state and federal and all the different leaves and how they can differ from each other. Again, speaking from personal experience, we've had a lot of clients reach out in the past couple years where remote work is becoming more and more popular. And, to Earl's point on that 75-mile radius or an employee working where at least 50 other employees are located, that creates a challenge where you're a Pennsylvania-based organization. You have a brick and mortar in Pennsylvania, but you've started to hire remote employees across the country. Those employees might not necessarily be covered by some of your traditional FMLA policy, and that's come up a lot more recently than I've seen in years past. Along with, like Earl hit it on the head with the with paid family leave. Not only are there more, I think it's like 12 states now, 11 or 12 maybe, that have paid family leave policies. Some in that infograph was great. I mean, some have up more than 9 different types of state paid leave policies, and on top of that, some employers are starting to implement their own paid family leave policies. So it's really important to really, like Earl said, rely on the experts to help you with that, whether that's a carrier or a third party or your broker. I would welcome those conversations. I know Earl would as well. So consider us a resource in that regard. Um, Earl, can you talk about how this question was actually about paid family leave? And they don't mention a state here, but how that would coordinate with FMLA? Do those stack or run concurrent?
Typically, they'll run concurrent, so it's basically adding in a kind of a paid component to the FMLA period. Most states have tried to kind of mirror the requirements and the duration, but then to continue to add in that paid component in those different states. Like I said, you made a couple of great points there. Really, and again, I think COVID was a little bit more of the catalyst in having employees work remote. I think remote work obviously spiked significantly through COVID, and as we kind of came out of that period, I think a lot of employees as well, kind of said, "Hey, we kind of like this setup, and it creates some efficiencies for us." I know just looking at our office, we have a brick and mortar here in King of Prussia. We used to have, everybody would come into the office. Now we kind of have a couple of days a month where folks come in. Everybody can come in every day, which I'm usually here, but some folks don't. They may be remote. Some folks live in different states. So we have some folks that commute from New Jersey and from Delaware. So important to understand the different components and complexities of managing that. Now, obviously, Principal's a large, national employer, but if you've got a small kind of family-owned business that may have employees that commute out from different states, important to know and understand how all of those things kind of come together.
Yeah, great point. I think it's also important that, these business owners, HR are paying attention to their payroll, right? We've had conversations where, payroll isn't taking out the state, they hire someone in New York and they're not aware of the workers' comp or the, paid disability that they need to be paying, or the payroll starts deducting it but is putting it into escrow instead of paying it to the appropriate state. So there's so many moving parts. That payroll piece is just a whole nother animal in itself. So again, rely on people like Earl and myself to really help you and use this as a resource. All right, man, that's it. I don't see any other questions that came through, but again, that was super informative. You somehow found a way to keep me engaged this entire time through a topic like FMLA. So I appreciate you. I appreciate our partnership with Principal Earl. Thank you, everyone that hopped on today. Remember, this is recorded, so you can reference back to it at any time, and that handout would be downloadable if you go back to a recording too. So take advantage of that. I know I already downloaded the handout myself. So I hope everyone has a great rest of the work week. Earl, thank you again, sir. Take
My
care, everyone.
pleasure. All right. Have a great day, everybody.